Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about long-term offenders. Cases that should have gone to the Supreme Court of Canada, but didn't. Leandro Acevedo was the subject of a long-term offender application. In the course of the hearing, the judge relied on personal characteristics of Mr. Acevedo for the purposes of determining whether he was more likely to engage in long-term offending. Mr. Acevedo argued that those characteristics were caused as a result of post-traumatic stress disorder. They weren't inherent personality issues that he had, but instead were the result of a mental health issue that he suffered as a result of serving in the military. The court denied his application, he appealed, and the Supreme Court of Canada denied leave to appeal. And this case obviously raises very important issues. There is a massive legal distinction between somebody who is a long-term offender because of a propensity to continue to commit crimes, as opposed to somebody who suffers from a mental health condition that can be treated and managed. And while Mr. Acevedo wasn't found not criminally responsible, his behavior and his circumstances certainly inform whether or not it's appropriate for the court to grant the order. And the case law isn't very clear in relation to how to factor in mental health conditions, particularly ones which could be managed, in determining long-term offender orders, leaving a lot of discretion to the judge, as opposed to setting up a process by which medical and psychological and psychiatric evidence could be introduced to assess whether or not a long-term offender order is appropriate. And unfortunately, the Supreme Court of Canada missed an opportunity to protect individuals from lengthy periods of supervision that can be imposed by the court who are not requiring those periods of supervision because their conditions can be managed more effectively through using resources with supporting their mental health, shorter periods of probation to get them on the right track, and then allowing individuals to continue with the work that they've been doing. This was an opportunity for the Supreme Court of Canada to really recognize the role that past trauma can play in future mental health and the way that mental health can play in somebody's prospects of reoffending. And unfortunately, they missed an opportunity here to really get into an issue that is evolving both in the social sciences area as well as in the medical and psychological community and incorporate that into our legal system. Hopefully there's another case where somebody is able to bring these issues forward and the Supreme Court of Canada takes the opportunity to develop a more nuanced understanding of how mental health affects long-term supervision orders. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.